And I talked to my grandpa, and he told me, he said, if they want to win the war, it don't look too good. He said, don't say that, grandpa. We cannot lose the
Their record here is very low. To get designated as a Superfund site, my understanding is that the governor has to sign on. She gets one opportunity to designate a Superfund site a year. She could designate this as the Superfund site, but the state has to become financially responsible for the cleanup and then recover the damages directly from the polluter. So I've heard lots of arguments about this, and this is just an example I'm giving about why I'm reluctant to weigh in on this as an environmental commissioner, because our duty is to provide our best advice that we've heard from the community, to integrate it and to provide some advice to city council about what should happen. And now my first question that I don't really know is, does anybody know, is this a make or break thing at this point? Is there no further negotiation? Do the parties have to accept it, or do they have to reject it totally? And if so, then what impact would that have on the judge's decision?
So, Steve, I'll just respond to that real quickly. Is we don't know. I mean, I think there's a lot of unknown. What happens if one jurisdiction approves the CJ and the settlement agreement, and what if the other ones don't? What's the judge going to do? The judge could certainly quite possibly listen to all of the discussion in his courtroom and decide on a judgment himself. I think we're just in uncharted waters, and nobody can tell us exactly what's next. I think, Councilmember Bannister and I have gotten, dozens and dozens of emails urging us to reject this in its entirety. I think I don't know if there's room to move on some of it. I don't know if there's room to move on none of it. I think some of it, certainly all of the attorneys are paying attention to all of this dialogue. If there's room to move, I think it's because the judge makes people move.
Okay. So does the judge himself have any power to modify any of this consent judgment, accept or reject parts of it?
Oh, I believe so. I believe he can force a judgment down on us, but I'm not a lawyer. I'm just kind of repeating some of the things that I've heard from different attorneys that I've been talking to. I know that Judge Connors is interested in hearing from the public on this in his courtroom. There had originally been discussion of a opportunity for the public to come and comment before him. I don't know where that stands right now. Maybe Councilmember Bannister has more information on that than I, but I think that would be an important part of his deliberation, to be able to hear directly from the public in his courtroom.
Mhm.
I haven't heard that he has scheduled that yet, but no, I haven't heard it specific on that. Judge Connors.
Okay, so will he be accepting comment after October 22nd, or what is this date? What's going to happen on October 22nd?
Steve, this is Dan Bicknell. Can you hear me?
Okay, yeah, okay. First of all, I want everybody to raise their hand if they want to speak.
How do you raise your hand?
To answer some questions because he has some knowledge in this area. So Dan, go ahead. Dan, go ahead and speak. You're muted.
Which number is Dan? Is he the 248 number?
432.
Okay, I'm gonna ask him to
You
unmute.
can leave him unmuted.
Okay.
Thank you very much. Yeah, on October 22nd, the judge is going to have a hearing, and that hearing will be to see what is the status of everyone's review. How does the city look at this? How does the county look at this? How does Scioto Township look at this? And generally, how does the public look at this? And what's being asked of us now is to take a look at the Fourth Amended Consent Judgment and accept it or reject it. That's what's being asked of us. Gelman has said that this is the most that they're willing to give at this time. So either you guys are going to agree to this or you're not going to agree to this. There's no ability to go and say, I want X, Y, and Z, go back to the negotiations. The Attorney General has indicated in a card meeting recently that if it is rejected, that likely the interveners and the state will go back to court with Gelman and try to get a better deal or whatever.
Okay.
There is the possibility, I think as Chip was talking about, that the judge can just say, well, okay, you don't like the fourth consent judgment. We're here with the third consent judgment. I'm going to potentially just take that third consent judgment, and I'm going to order, as he has in the past, things be done, such as to make the drinking water criteria be current at 7.2 instead of 8.5, which it is in the third, and make the GSI 280, which is the updated value, instead of 2,800. So the judge has a lot of latitude, but on October 22nd, he wants to hear from everyone on what their view is. But right now, your charter is to accept this or reject it.
I see. So, however, it would be possible for us to suggest modifications.
No.
Or who would, I guess it goes back to the attorneys that would that would restart these negotiations that have been going on for several years.
Yeah. Again, Brian Nagel, who's the Attorney General, Assistant Attorney General on this, had said that if this is rejected, that likely they will go to court and try to, through the court process, in front of the judge, not have a settlement, which this is, but force Gelman to do specific things. So right now, we're being asked to say, do we agree with this take it or leave it offer by Gelman?
I see. So, I see. Okay. Is anybody, Peck, you'd like to speak?
Hi. Yeah, so why don't we, that makes total sense to me. I'm not a lawyer, but it makes total sense to me that, and all we're doing, right, is recommending to council. So what we ought to do is, this is not a motion, this is a discussion, but we should recommend rejecting this settlement, then say why. That's a whole bunch of whereases, I suppose. And then we should say something about what we prefer, which is much stricter, much more, what would be called, comprehensive cleanup of this plume to prevent it from spreading throughout the region under Ann Arbor and adjacent properties or townships, or whatever the right word is, to prevent it from entering into the river, to prevent it from entering in to whatever, and that and to protect the three sister lakes, or whatever they are, the sister lakes. So we should actually list a few criteria that we think are really critical. But from my point of view, reading all this stuff, it looks to me as though this is a Superfund disaster. Gelman is trying to get away with murder, probably literally, and we can't let this happen to Ann Arbor and the people of Ann Arbor and the adjoining townships or whatever. It's just the wrong thing to do. And so we got to say that loud and clear to council, and then hopefully they too will agree to reject this settlement and return to court. And if it returns to court, of course, it costs Ann Arbor money, and but maybe we'll get an outcome that is good for our citizens. This is not a good outcome for our citizens.
And what you just ticked off there could be part of the whereases. It would be whereas this does this, whereas this does that, where it doesn't do this.
Okay. Yeah,
and we got to do it in an expedited way. I don't know when council needs this by, but we better make sure they have something. And so the perfect is the enemy of the good here. We got to make sure that we get. Well, we got to get them something. And I prefer to tattoo it on the Chips and Ann's arms or something. No, I'm just kidding.
So
council votes on the 19th on this issue.
All right. So that's our last opportunity, is on the 19th of October, which is before our next regular meeting. So so let's see, anybody else want to make a comment here? I think Rita has her hand up. Go ahead.
First, I want to thank you, Steve, for writing a draft resolution that rejects this consent judgment. Thank you for taking the lead on that and for working very hard to push forward with this meeting, which was difficult under the timing that we had. But I totally agree with rejecting it. I believe that this does not do good for the citizens of the area, and that we should make that clear. So I'll just make it that short right now. I think there are plenty of reasons. We've heard good reasons, and we should, in my opinion, we should proceed with stating a rejection.
Okay. I've since modified it. So why don't I share my screen now? And what I'm going to do is just share my screen, and hopefully you all can comment on it, and we can just potentially draft this online together. Is this possible? Is it desirable?
I would just suggest that perhaps we might want to hear from one or two other council commissioners if they want to speak before we look at that. That's my suggestion.
Yeah, Chris.
I've been on the commission since the mid-2000s, and this has been an issue boiling ever since. And I've watched it all the way back from the beginnings. Matt Naught's letter was extraordinarily accurate about the issues involved in this particular change and how things might happen. He lives on First Sister Lake. He gets up every morning and looks at that water body. He was very instrumental in getting the storm sewer system, retention system designed just beside First Sister Lake to try to improve water quality. And he did what you've been doing, Steve, for many years, trying to get involved in the negotiations and how things were going. Most of that time he was stonewalled and left out because of unwillingness of the courts to make Ann Arbor a party to the discussions. I have listened to the guy who's led I think he leads CARD, it's called. Forgive me for not remembering his name, but he's been a trooper all the way along, and watched the graphics that he's presented over the years of the movement and direction of the plume, and have been highly disappointed that the effect of treatment and groundwater withdrawals has really not slowed it one iota. If I watch the pattern of groundwater, I think short of a miracle, this plume is going to reach the river somewhere near where Allen's Creek comes in. And I think we need to thank our lucky stars it's not going north into Barton Pond. If this consent judgment was a site plan issue that was presented to the Planning Commission and to the council, it would be roundly rejected. We don't permit contamination of our high quality wetlands. We don't permit overwhelming hydrological changes to our wetlands. We would just say no. And I think for that reason alone, we should say no to the consent judgment. The right thing to do, in my view, is to treat the water better to current standards and pipe it below Barton Pond, wherever they want to do that. There are no people below Ann Arbor who are drinking Huron River water. We are drinking Barton Pond water. 85% of our water comes out of that pond. So if you say, no, we don't want to do that, and if you say, no, we don't want to contaminate and overwhelm First Sister Lake, then a pipe of some sort down below Argo Dam makes the most sense. I understand this is expensive. I sympathize. When this pollution happened, it wasn't known, first of all, that this chemical would be so water soluble and so portable in groundwater. It wasn't known, or perhaps it was by some technician, but not maybe by the bosses, that it would cause such a problem. And the expense of fixing a groundwater contamination issue of this sort, really fixing it, is extraordinary. We can just improve it, and most of all, protect our drinking water and our wetlands and native lakes.
Anybody else wish to make a comment? So I'm going to say something further. I have a few questions, and I'm wondering, so I would like to put up my document and share my screen so that we could edit it online starting very soon, but I had a few questions that struck in my mind reviewing all this information. And I agree with you, Chris, that this has just been a shocking lack of technical expertise being consulted at the proper times. There's been a shocking lack of transparency, and I think we're all seeing what the results of these deficiencies are. So I'm hoping that we can correct that at some time in the future, at least within the city, and if not the state and the federal government. So my first question was, well, who collects the data? Is it the polluter? Or is there some independent third party that actually collects the data about, what the concentration of dioxin is in these in the monitoring wells and surface waters?
Steve, this is Dan. Can you hear me?
Yeah, hi Dan.
Yeah, it's Gelman who does that for the most part. They collect samples from the monitoring wells and have that analyzed at their lab, report that to the state. And from time to time, the state will share samples with them, and the state will analyze it and have Gelman analyze it. But for the most part, Gelman is collecting all the data and providing it to the state, whether it be surface waters generally or monitoring wells. There was a program that the state and the Water Resources Commissioner did on Allen Creek that was done by them, but otherwise, generally, it's Gelman's data.
I find that troubling.
So
As do some of others.
Yeah.
I believe the city has done some of its own testing on a few spots that Gelman has not been subject to be responsible for. Like, I think there has been some data that has been collected by the city that they've run in their own labs too. For the sister lakes and things like that. That wasn't part of Gelman's responsibility, is my understanding. but that the city has done some of their own testing on that, is my understanding. So
I think that's true.
generally speaking, it's Gelman, but I think there has been some supportive testing from the city just because they want to be able to test more spots than what Gelman is officially responsible for.
That would be prudent. That's a situation that's ripe for manipulation of all kinds. So, I mean, where I come from professionally, you do not allow that. You have an independent third-party lab. You use blinded samples. They test them. They give you the results, and you can request a repeat and pay for it. But for Gelman to be responsible for all the data, the sampling, the data generation, and the dissemination is, I think, a recipe for potential disaster.
So it hasn't helped that since John Engler's term in office, the governor and Republican legislators have done everything they can to tell the Department of Environmental Quality not to regulate.
Mm-hmm.
Through this entire time period, we've seen a drastic cut in the budget of DEQ, a drastic cut in the number of employees, a drastic pressure on them, relentless pressure on them to back off. And the idea that the polluter can monitor his own work is part and participle of that. It's been relentless since the mid-1990s.
Well, I'm not sure what authority the city has to request, to insist on that, or to make that happen.
We've had none.
Steve,
Yeah, Rita.
I'd like to suggest that that be one of the resolves that we add. It may not happen, but we could at least make a resolution or add to our resolves that an independent testing be arranged.
Yeah.
I think that Rita brings up a good point, Steve, is that, you know, if this body can craft a resolution that has some specifics in there, that's probably more useful for council and in particular our attorneys to try and move this ball forward than just a general outright rejection. I mean, I think, you know, to cite what these things are and do that. And maybe that requires another meeting on the 18th, you know, for this body to spend a little time kind of crafting the specifics that are objectionable and coming back with a more detailed, you know, grounds of rejection.
Yeah, Chip, that's my instinct as well. I was thinking that let's get as far as we can today, and then hopefully we can work in the background just to do, you know, and tweak it a little bit, and then we'll have a second meeting to approve it if we run out of time. Because I would like to end this meeting at 9 o'clock. Beck?
So this all sounds good. I'm just, we will only have limited amount of expertise that's necessary to suggest how to move it forward beyond rejecting it and saying things like there shouldn't be further contamination of our wetlands and lakes and rivers, or the spread of this plume underneath Ann Arbor. You know, we can say things like that. The question of how to do that would require very technical assistance. And you'd also, of course, need to bring in a lawyer or team to be able to figure that out. So what we need to do is probably focus our recommendation on the city doing just that. You know, rather than trying to let the polluter decide how to deal with this. We need to somehow have a team of experts that represent the people of Ann Arbor and adjoining region that has the expertise, both technically, pollution-wise, hydrologic-wise, but also legally, to put together a case that this judge will be able to consider as an alternative to the settlement. You know, in other words, Ann Arbor has to fight the efforts by Gelman to get away with this.
Mhm.
And, you know, it's a pretty typical situation, I assume. A
Mhm.
polluter wants to save money and absolve themselves of responsibility.
Mhm.
And people are going to be hurt. Natural systems are going to be hurt. Property values are going to be hurt. You name it. You know, this is not good.
Mhm.
And Gelman's just trying to get away with it.
Mhm.
And so Ann Arbor has to like step up. And so that's in essence what we have to say. You know, it's pretty darn obvious that that's the case. And we can't get into the specifics of what Ann Arbor needs, but we can do it maybe in some general ways. But it's, you know, we got to be a little careful that we don't try and do something that would be impossible to do well.
No, I agree, Tech. I think we need to avoid asking for means, but we need to focus on goals that the community would desire. We need to focus on goals. And in respect to the last 5 minutes discussion, one of the resolve clauses I have put in there is that the city should impanel a professional group to peer review the data that they get, at least. You know, and then also provide um, some kind of legal advice about pathways for contesting some of the arguments that Gelman's going to put up, and identify some of the constraints in both state and federal law that prevent us from getting this cleaned up to an adequate level. So, Bob. First Bob and then Chris.
Thank you, sorry.
But this all gets at one of the things that I'm really struggling with, and that is presumably someone has been negotiating on the city's behalf here, right? I mean, who is that, and what have they done, and is there some reason to think that you know that they're recommending that we go forward with this? I just, you know, there's so many questions.
Yeah, this is Dan. I can help with that. That was Fred Dindorf, who was your lawyer, outside lawyer, and Larry Limke's been your outside consultant through this. And really, the way that it has been framed is not really clear. And what I'm trying to say is that you all have tried as interveners to get a very substantive cleanup. But Gelman has rejected many of the things, I assume, that Fred and Larry have asked for. But because all these negotiations have been confidential, we don't know what they've asked for. The only thing we know is Gelman says, this is the bottom line. Take it or leave it. So we are looking at what maybe Fred has already asked or what Larry has already asked. We don't know because of the confidentiality agreement. We are unclear.
Yeah.
Yeah, Bob, Dan's exactly right. This confidentiality agreement has really made it difficult for the public to get information, to see where things started, to see where they've been going. And, you know, I'm not one of these people who's going to criticize the attorneys. You know, our team is working as hard as they can to get the best possible solution. But, you know, let's not sugarcoat it. Gelman's not our friend. They're not our partner. They're not wanting to do anything. And when that's your adversary, sometimes you just end up in court. And sometimes the law is with us and sometimes it's not. You know, maybe at the end of the day, it's just better to go to court now. Like, I don't know. I mean, it's going to be long. It's going to be expensive. It's an unknown outcome, but maybe that's just where we are. And, you know, I think we've been doing this dance. You know, it was such a heavy lift to become an intervener in the first place back in 2016. And the discussions that have gone on between 2016 and 2020 have been things that a normal person that's not a lawyer would think could have been dealt with in a couple of months. And we're talking about 4 years here. And, you know, at a certain point, you just either got to take care of your business or you got to get off the pot. And, you know, no business is being taken care of. And I think what I would be looking for, and I'm not going to speak for any of my other council members, but, you know, I think we're looking for some guidance. Is it, tell us what the most important or the most egregious things in here. Like, I can tell you right now that the first Sister Lakes discharge bothers me greatly, and that I cannot vote to move forward on something on a resolution that includes that. Now, whether or not Judge Connors will say, oh, well, you were close on other things and we can do this and that, I don't know. But that's kind of my take on it, because that's just moving our problem someplace else and creating a new problem that we don't have any data on.
Mm-hmm.
And at the end of this, like, you know, I don't know, maybe we end up in court. But I think, you know, some of what I would like this body to give us is things we should be telling our attorneys, like, this is what we need to see in this settlement agreement. I know council has given the attorneys quite a bit of direction.
Okay.
Yeah, Steve, this is Dan. In that presentation that I sent you all, I tried to show the advantages and the disadvantages between the fourth consent judgment and the third. For example, I pointed out that they threw out the Maple Road containment objective, which would have stopped east of Maple Road contamination. So I would ask people, since I can't give the presentation right now, to just take a look at what I had sent, and I think you'll see, Chip, that there's lots of things in there that they have excluded or need to include.
Mm-hmm.
Well, Dan, I've shared that with the attorneys, so, you know, I think they've got that information.
Mm-hmm. So I've read those comparison of the third consent judgment versus the fourth consent judgment changes, and there seems to be a strong argument for the fact that the PZ, you know, that zone is going to be fixed at where it currently is. And I'd like to remind people that last time I checked, 95% of all the Superfund money has gone to lawyers and not to any claim.
Well, that's not actually true, but I'm not here to debate Superfund. I'm here to look at the fourth amended consent judgment.
Exactly. So in my mind, the risk is if we reject it totally, then we're going to be continuing with things as they are for an indeterminate amount of time until something else can happen. So that's.
But you're going to be going back to court, according to the Assistant Attorney General.
Yeah, but will it take? We already have an example where it might take 4 years to get something else. Meanwhile, you know, the plume continues to migrate to the river under the current conditions. So, is there any advantage? Yeah, are there parts of the fourth consent judgment that are advantageous to keep?
There are a lot of movies.
Summary, again, my summary has been that actually the third amended consent judgment, the current one's better. It has more action than the fourth.
Mm-hmm.
All you have to do is upgrade the drinking water criteria and the groundwater surface water interface criteria, and it's much more protective than the fourth.
I see, but those are the two that need to be incorporated from the fourth consent judgment, as you're saying. It's the new drinking water criteria and the new GIS criteria. Is that correct, Dan?
That's correct, and I can't believe the judge wouldn't immediately do that. How can the judge sit there and say, okay, you guys can't come to an agreement, but I'm going to let you continue to violate the current state laws? No, I'm going to issue an order. And remember, the judge has issued 3 different orders that have impacted the second consent judgment. He ordered an expansion of the prohibition zone. He ordered an investigation into the Unit E, and he ordered additional remediation efforts. So it's not like it's odd for the judge to issue an order where he sees that there's right that's not being done.
Okay, so in other words,
hey, Shannon's been trying to say something for a while.
I'm sorry, Shannon. Yeah.
I guess I would like to say that I think that something that was really clear to me with this last round is that nobody was looking at surface water in terms of the solution. I think that's what Chip is getting at. That it seems like it's been much more oriented to groundwater, but that just to kind of throw this, oh, by the way, we're going to add, 4.5 inches a day to the first sister lake every day. I mean, it's like that just has enormous implications. And so I feel like that I know we don't have any access to what people are talking about, but one of the things that I would suggest in terms of some sort of tangible movement going forward, if we're going to ask for anything, would be that surface water understanding and hydrology at the surface would be part of the negotiation as well, besides just the groundwater contamination piece, because it's just incredible to me that they would I mean, it would fill up fast. So it would basically spill over, into Honey Creek, because there's a connection under Wagner there. But we don't know where that weir is set. There's all kinds of things. We just need to understand it. And it's like there's just no mention at all of what's going on there. And some sort of, I mean, if that's going to go forward, some sort of at least pre-study and post, to understand what that impact would be. I mean, that's huge. So I want to make sure that moving forward, that surface hydrology is part of the discussion, because it just seems like it's has been more focused on the groundwater piece, which is obviously super important as well. But I would like that to be included. So maybe that's you kind of get at that somewhat in the resolution, but maybe to call it out a little bit more directly in terms of how the issue was understood.
Mm-hmm. Okay, Chris.
If you take Paul, an Australian company, at their word that this is the bottom line, and given the nature of this judgment and its really awful ramifications, I think one needs to take them at their word. It means an Australian company that's abandoned our town is about to stop cooperating. And that is a big gravity. If we could get it to be a Superfund site, then maybe 20 years from now, there'll be some money there that could help us. It means, in my view, that we, the people of Ann Arbor, are going to have to fix this problem as best we can. I wouldn't waste money on court. I would get busy trying to figure out how to deal with it.
Mm-hmm.
And raise the money to do it. The history of companies abandoning these things and going bankrupt or whatever it takes to avoid obligation is huge.
Mm-hmm.
And I think that's where we're going.
Right. So what are you saying is that council should not agree to block Superfund option.
Agreed.
Okay. Let's see. So yeah. Any other comments at this point? So let me write down what I have so far here. One is that we recommend that data be acquired and made public, and well, that any data about contamination or pollution be done generated by an independent third party, and that it be publicly available. How about that? Okay. The second one would be absolutely no discharge in the first sister lake. Any diversion would have to be to other site. I'm surprised that they didn't propose to take the treated water and inject it into an underground well on the site.
Probably not a reasonable aquifer to do that with here. And deep wells are very expensive.
Well, yeah, but that's one way of, if your dilution and dispersion, if dilution is a solution, then that's one way of doing it. At low levels, if they treat it down to 7 parts per billion.
John Calvert would like to speak.
Yep, John.
Thanks. Yeah, so while we're on that point of the the water discharge, do you still have in the one whereas clause about the 100-year rain event? And the reason I asked is I've seen people calculate that in very different ways. And I don't know if we want to kind of commit to that without really having the analysis for that, but maybe other folks know. I'm just thinking I would feel better if that was not in there in the way that we talk about the groundwater discharge or the water discharge impact around there, I think would make it stronger.
No, I'm with Shannon. Go ahead.
I just would say I was suspicious of it too. And so I ran the numbers and I came up with the same thing.
Mhm.
So I actually feel pretty confident that, I mean, it is naming something. So I get that in terms of, in terms of like, it is a little tricky, you know, to get in and name that. I agree. But I was also kind of like, who did the math on that? And so I came up with a very similar number, but I think that we don't have to say 100-year. I mean, we can still get at the idea of it, which is, I think,
A major event.
Yeah.
Yeah, I
Well,
mean,
it would be, yeah.
yeah. No, I agree. I would be more stringent and just say no discharge into First Sister Lake. That's what I'd recommend. And then if it's considered, it need only be considered further if there's a thorough hydrology study and that there's a reliable and constant monitoring that at least it's been treated down to 7.2 parts per billion before it's put in there. Because, you know, what I heard in Lemke's presentation is, oh yeah, you know, the lake will fill up, but it'll discharge. And so, but where will it discharge? Right into Honey Creek.
Right.
So what if they're not treating it down to drinking water standards and running it down here on Creek, upstream of our municipal water intake?
Right.
So, so I'd rather leave it at that and just not even mention any rain events or, you know, because a thorough hydrology study would give us some better idea of what the hazards were, what the flood risks were. But there's another risk of, you know, untreated dioxane getting dumped into Hunting Creek.
Right.
And so, okay. And then I mentioned the peer-reviewed panel for review of technical data. The other one was vapor intrusion. We haven't talked about vapor intrusion, but there has been a concern that when the plume gets close enough, it's going to, we might get some potential intrusion of dioxane vapor into residents' basements down in the Allen Creek watershed. Does anybody want to comment on that, or does anybody have an opinion about that, or some closer knowledge? Dan?
Well, the problem that we have is that they've never done a study to show where are the routes of exposure as this thing moves through the city. When they originally set this up, they said, well, the groundwater is going to go from Maple Road and go into the river. But that's not really all the things that can happen to it. It actually can go down, and now in the Old West Side in West Park, it's within 10 feet of the surface. So like you say, you have the exposure where the dioxane, kind of like radon, will evaporate up and go into a building, causing vapor intrusion. You can also get a building that could get flooded, and if it's flooded with the dioxane, there's another route of exposure. And then you have workers in a trench. You can imagine a person cutting a trench to lay some pipe, and if that's within 10 feet of the surface where the groundwater is contaminated, that person can become contaminated. So yes, in the Old West Side and West Park areas, there are routes of exposure that this does not address.
Yeah.
And also please the city of Ann Arbor, the Ann Arbor Charter Township has, has wells between the Plume and Barton Pond, which we all don't reflect on. But that's a major concern, of course, the Ann Arbor Charter Township, is there's residential wells right on that path as the Plume moves towards Barton Pond, which is where it's partially going.
Mm-hmm. Yeah, that's their concern, not the city of Ann Arbor's. I'm not to be blunt, but I think given our time restraints right now, we should really restrict ourselves to thinking about what you know, what we send to council, who's responsible for, you know, the city of Ann Arbor, not the township.
I think you could probably phrase it, Steve, that the consent judgment should be protective of these routes of exposure in the Old West Side with the shallow groundwater contamination.
Yep, no, I think that's good. Okay. Now, yeah, because I
Steve?
do. I'm sorry. Anybody have their hand up?
Yeah, Steve, there was another point I wanted to bring up to see what folks thought about this as an additional kind of issue to address is the lack of performance criteria for the phytoremediation plans. It just kind of has a basic, you know, we're going to plant some trees, but no kind of performance criteria in terms of what are we looking for, what's going to be success, what's it's very vague.
Mhm.
Yeah, all they are required to do is remove mass, which, like you say, is very big.
Yep.
Mhm.
How does phytoremediation have to do with removal of mass?
Well, technically what they're saying, which is partially true, is that the dioxin will get sucked up with the water into the plant. And like all plants, they respire, they breathe. So the dioxin will come up into the plant, and as the plant breathes and respires, it's going to go off into the atmosphere.
So I know a little bit about phytoremediation, and usually it's very much triggered by certain plant relationships. It's like certain species are actually part of that whole system. You don't just use whatever plants are out there. There's targeted plants for targeted, you know, issues. You don't just say phytoremediation. You know, you would list the things that are specifically set up for whatever 1,4-dioxane is, not just general, you know, evapotranspiration.
Yeah.
So
Well,
that
they
seems a
have,
little
they,
vague.
yes. Well, that's the problem that we have with this. A lot of this is in the future, they're going to propose their plan. You see, they don't lay it out for us.
Wow.
But generally, poplars are supposed to be pretty good at this because they have a fairly deep root system.
Mhm. Dan, you're fading. I can't hear you.
Sorry. Yeah, the problem is that we don't know because they didn't tell us what their plan was. But generally, poplars are used for this sort of phytoremediation.
So they would just plant poplars everywhere? I mean, it's like...
Yeah, that's it.
Well, it was for a specific site near the Gelman facility, if I remember correctly. It
Okay.
wasn't kind
Well,
of a
right.
general
I'm
approach.
sorry. I'm sorry. Yes, it was the
targeted
pond
to a
1 and
specific area. Yeah.
It was,
yeah,
it was
it was the pond 1 and 2 area and the marsh area.
Okay.
I
Well,
apologize.
the marsh area near the Gelman site itself.
Yes, all this is going
Okay.
to be on the Gelman site, not off of the Gelman property.
Okay, the phytoremediation is for their site. Okay, that clarifies that. Thank you.
Yes, ma'am.
I just want to add to that they didn't provide any information for success with this method very specific to dioxane at all. It's just stated as a method.
yeah. Yeah, it's that was bizarre. So Dan, is there so are all the hot spots that you're aware of that have been admitted publicly by Gelman, are all those hot spots being treated in this plan, in this future plan, or do you think it's important to treat all the hot spots?
I think they should be treating all the hot spots, yes, but what they do in here for the groundwater off-site hot spots is they really don't do enough work. They don't do enough groundwater extraction. So one of the comments one of the whereases that I would have is that they need a properly designed groundwater extraction and treatment system to actually, halt the plume and clean up the aquifer. You got to remember that what they did is to estimate and to put the number of groundwater extraction wells out there and how much they should be pumping. They just simply use the 200 gallon per minute transmission line that they currently have. They didn't say, okay, here's where you need to put the extraction wells and here's what the rate should be to capture this area. They said, well, wait a minute, this line can only carry 200 gallons per minute, so where should we put the wells? So there's never been a remedial design investigation to determine what is necessary to halt the plume, which is something they should be doing, or should have.
Yeah, I would add a resolve clause that would say treat all hotspots treat all hotspots using best technology available.
Yes.
Because I heard there already is another one. Okay, well, let me put up my screen now. Does anybody else want to make a comment at this point? Peck. You're muted.
No, I didn't have a comment, sorry.
Oh, okay.
All that excitement for nothing. I think I must have just been going like this.
So,
This is Ann.
hey, Ann.
Yes, did we want to include maybe even on that last resolve clause, something about the CJ allows for that 500 parts per billion, and then Gelman can walk away, which was, I think one of Vince or James, one of the callers, put out that that's a non-starter. That's way too high.
I'm sorry, could you repeat that?
This fourth CJ allows for 500 parts per billion as the threshold that then Gelman can walk away and consider it done. And that was too high.
I think, aren't those limits set by state law and federal law?
No, sorry, Steve, but what they said is that if you operate the Park Lake well to a remediation level of 500 parts per billion, as Ann's talking about, then you can turn it off.
Wow.
It doesn't mean that things below 500 parts per billion aren't going to cause a problem. It'll just allow that 500 part per billion below 500 part per billion plume to move. The same thing on site. They have these 3 production wells, PW wells on site, which are extraction wells, and their cleanup criteria is 500 parts per billion as well. But the rub is these other wells, their criteria is until they attain the eastern area objectives. And you can attain the eastern area objectives by just simply expanding the prohibition zone or using a mixing zone-based groundwater surface water interface value. So as soon as you attain the prohibition zone objective and the groundwater surface water interface objective, then you can turn all the off-site wells off in the eastern area, where most of them are.
Well, and that goal right now is 7.2 parts per billion?
That's the drinking water criteria, but they don't have to hit the drinking water criteria is what I'm trying to say. As soon as they find that the prohibition zone can be expanded, okay, which they can continue to expand if the court agrees, okay, that satisfies their prohibition zone containment objective by expanding the prohibition zone.
Sure.
The second thing they have to do is there's a groundwater surface water interface value. That's where the groundwater enters the surface water. And if they apply a mixing zone-based groundwater surface water interface value, which they can, where it enters into the Huron River, so it goes all the way through the city and enters the Huron River, then they're done with that objective. So as long as they get those 2 objectives, they can turn off the groundwater extraction systems that are off the site, except for the Park Lake, which you got to hit 500, and the ones on the 3 on the site, which you got to hit 500.
Okay.
That's why I'm saying that the third amended consent judgment is very good. It doesn't allow that sort of shenanigan.
Mhm.
And it would produce much more work if they just changed the drinking water criteria to 7.2 and the GSI to 280.
Mhm. To 280?
Yeah, the groundwater surface water is 280 parts per billion now. In the past, it was 2,800
Mhm.
parts per billion.
Right. Oh, I just thought you said 208, but you meant 280.
280, I'm sorry. Yes, that's what I was trying to say.
Okay, it might have been me. So, all right. So let's, Galen, can you let me share my screen?
Yes. All righty.
But to Ann's point, the 500 parts per billion has no scientific basis.
Mhm. So what, so how would these numbers be changed, Dan?
Well, it's a simple thing, you know. You need to halt the plume and restore the aquifer to drinking water criteria.
Mhm. Do we have the authority to demand that? Or are we restricted by state and federal law?
You can ask for it. I'm
You can
sure
ask
your
for it.
attorneys may have asked for it, but Gelman is not yielding. That's the most concerning thing here, is that the prohibition zone can continue in the eastern area to expand. And as it does that, it takes the private owners' water rights away and just lets the plume go and does it again, and does it again. And that's what happened, as you all may remember, in the Evergreen area. Originally, the prohibition zone in 2005 or 6 didn't include the Evergreen area. Then as the plume expanded, they expanded the prohibition zone in 2011 to take on those houses. And now they've expanded it again. So their strategy is to just keep expanding the prohibition zone, taking away private property owners' water well rights, in implementing institutional controls and land use restrictions, and do it all the way to the river. And that's what this document allows them to do.
Okay. So I'm not a very good typist here. So y'all can talk among yourselves while I'm doing this. Let's see, Rita, do you want to moderate? Or should I find a secretary to do this? I think.
Any comments, anyone?
I guess I would ask Dan, how would, like, if you were to help us craft this, knowing that what Councilmember Smith is asking for and what we've been discussing to date, and given the sort of restrictions that you know about, what do you feel like would be the most effective way to edit this document?
I can pass on some suggestions. The Ann Arbor Charter Township passed this resolution that said that they would not support the consent judgment, and I can give you some of the whereases from them. And I can give you some whereases, you know, that cover the areas that we've been talking about as well. So like, you know, you guys are the decision maker. I'm just here to kind of provide some regulatory technical thoughts.
Right, but you know, you're what we have right now. And I don't know that we're going to convene a panel in time, you know, for us to be able to, you know, I would, love to
Sure.
have Peck's idea of getting a panel together to be able to do this, but I don't know that we're going to be able to pull that off.
Well, what I can do is I can give you all a draft of a set of whereases that I think would address the majority of the deficiencies in the Fourth Amendment consent judgment, and probably what you guys would ideally like to have. And then you can, back and forth,
Yeah.
kibitz on that.
That sounds good to me, to kind of edit this to the extent that we are able to tonight, Steve, and then if Dan can share his technical expertise about what he feels like could be helpful for us to be able to pass this along, that we have another opportunity to be able to adjust it based on some of his wisdom around this.
Yeah, no, that sounds, that's a great suggestion, Shannon.
So I just have a process question about that. Do we have to convene another meeting like this in order to agree as a group, to vote on it? Or could we take an e-vote over a time period?
My impression is that we need to have a brief discussion and a vote publicly.
Yeah, the deliberations need to be public.
Mhm.
Okay, thank you.
But I can draft this document and we can all have some input into it first, I think.
I also like to just say that it seems to me that we don't, I totally like the idea of giving specifics to council, but I don't think that we have to solve all of the problems necessarily if we're in a tight time frame. And I think if we give the guidance that we've got to start on here, that council will get the point and can take it further and find additional consultation, I hope.
Rita's exactly right. Like, just say what the deal breakers are in this.
Yep, I agree. Okay, well, we've already talked about most of them.
Bob has a comment.
Yeah, just a couple tweaks I might suggest if I could. What you've got now as the last resolved clause, I think makes sense to be the first resolved clause. And I think it should probably be phrased that resolved that the Ann Arbor Environmental Commission recommend that Ann Arbor City Council.
Yep.
Or recommends, yeah. The Environmental Commission recommends that City Council reject. And then just one more thought, up toward the top, if you could scroll up to the very top of the document. So I think we need to introduce the idea of the fourth consent judgment. I would suggest I think the first whereas clause is fine, but I would suggest a second whereas clause saying something like, whereas the court has released for public consideration a fourth amended consent judgment. And then all those things that come after it are part of that.
I'm sorry, what was that, Bob?
I mean, I'm just kind of spitballing, but whereas the court has released for public consideration a fourth amended consent judgment.
Yeah. I'll tweak these a little bit. I still don't know what legally this is called, this consent judgment is called.
It's on the document.
Consent judgment to what?
It's the proposed Fourth Amendment consent judgment to the Gelman and state.
But they don't call it the Gelman plume.
It's on the document.
Yeah,
that's in
I'm
the,
just going to get it from them
yeah.
later. Okay. So let's just go down here from, we got the first two. What about the third whereas?
Mhm.
I don't personally, I think all the whereases are in pretty good shape, actually.
Okay.
One that I was wondering about was whether to split, where is it, there was an and one, let's see, the last one, and have a separate, whereas to emphasize the outreach to the EPA, so instead of having the EPA mentioned in the same, oh, sorry, I was looking at the old one. No, I don't see it.
I mean, what would the city do? Appeal to the EPA?
Consider, yeah. Mhm. Well, the thing is that the issue, as you wrote it the first time, was you said, whereas the city of Ann Arbor would be required to submit an order of dismissal terminating their rights to participate in the consent judgment and agree not to support requests to the EPA for Superfund designation. I would just put and that as a next whereas.
Mm-hmm. I'm sorry, where are we?
It's not a big deal. Well, it's not in, because I hadn't seen this new different version that you've got, and so it was your original version that had a phrase about the EPA.
Mm-hmm. Yeah, I just want to make sure that I think the city should reserve its rights.
I agree.
To appeal.
I totally agree, and that's why I wanted to emphasize it.
Yeah. Okay, so I'll figure out some better language with that, and then we can work on the draft over the next couple of weeks, okay? So I think we're getting close to where, let's see if Galen, are there any, so I'll finish this off tonight and send it to everybody and give everybody on the commission permission to edit, okay? Or to, and then we'll see where we get, okay?
I've got a question about process. I thought we were going to try to vote on this tonight so that it could be shared with council tomorrow, or that's not a priority?
That was my original intent, John, but we're getting, it's 8:51 now. I'd like to finish by 9, and we do have a public comment left.
Got it.
I'm not sure we can finish this off, so we might need a short meeting, like a half-hour meeting later on, to do a final discussion, public comment, and then tweak it and then vote on it. Is that
And
agreeable?
Ann indicated that this is not going to be voted on by council this week.
That's
No,
right.
the Wednesday night meeting is a public hearing for council to hear public comment. There'll be no action on the agenda.
Okay, so I would propose, does anybody want to propose a motion that we tweak on this document and then schedule another meeting before, clearly before October 19th, when council will vote on it. And that we will vote on it at that point. We'll have a brief meeting to discuss, tweak it, and vote on it. That includes public comment.
I mean, we didn't even introduce this formally, so I'm not sure that's even necessary. We can, as long as that seems to be the consensus.
Mm-hmm. Yeah, okay. Yeah, we can probably leave it at that, okay? That's my understanding of the bylaws. I wanted to make sure that we maybe have that formal option. Okay, well, why don't we end, do I have a motion to end discussion and to postpone further discussion and presentation of this resolution and a voting on it until a date to be determined before October, let's make it I'll bet the 19th is a Monday. So let's make it before the Thursday beforehand. So that would be, yeah, that would be October 15th. Okay. Okay, I'll schedule a meeting before October 15th, just like this one. It'll probably be shorter, and then we'll finish this at that time.
Can you get a copy to us so we can suggest edits to you?
Yeah, I'm going to share it with everybody on the commission. I'm going to try that got done tonight. Okay.
Yep, great.
Okay. This seems like the most expeditious method that doesn't, that still involves our full participation of us in the public. Okay. All right. So, Galen, why don't we pass to the second public comment period?
Okay.
So this is the second opportunity for public comment. This is an opportunity to speak up for 3 minutes. Please call 1-888-788-0099 and enter meeting ID 925-5309-1672. This information is also displayed on the meeting agenda and video feed. City staff will select callers that have raised their hand one by one using the last 3 digits of your phone number. In order to electronically raise your hand to indicate your desire to speak, please press *9 on your phone. You will hear an automated announcement that the host is allowing you to speak. When speaking, please move to a quiet area and mute any television or background sounds so that we may hear you clearly. Please state your name and address at the beginning of your comments. And please be patient. There is a delay of up to 30 seconds before a connection is established. Okay.
Okay. We have a question from Council Member Jack Eaton. Go ahead and speak, Council Member.
Thank you. Can you hear me?
Yes.
Yes, we can hear you.
Okay. So I'm not here to advocate any position, but I really do encourage the Environmental Commission to take a strong position for or against the consent judgment. If you have any questions on how to draft a good resolution, I would recommend that you read the Ann Arbor Township resolution. The Sierra Club Huron Valley chapter also sent us a letter in opposition to accepting the consent judgment. So I would even recommend looking at that for reasons. A consent judgment is an agreement between the parties. It's a means of avoiding a trial. And so it's not real likely that the judge will dive into the consent judgment and tinker with it. He may urge the parties to alter their positions and send them back to negotiate, or he may try to impose a couple of small items like the numbers, but he's not likely to engage in a lot of modification of the agreement. So in your resolution advising council, you should identify the reasons for your position. So for example, if you advise us to reject this, you might note that the polluter is not using the best treatment method. They're using a substandard treatment method that actually will reduce the dioxin but not eliminate it. The consent judgment only requires them to reduce the incidence of dioxin to 500 parts per billion. It allows for the further expansion of the prohibition zone. It will cause dumping tainted water into the lake, as you've noted repeatedly. And further, there's no metrics for measuring the success of phytoremediation. Those are just some of the reasons that you could mention as a reason to reject the consent judgment. I don't think that you should engage in suggesting what we should seek in a consent judgment. As Councilmember Smith noted, we've given our lawyers lots of great suggestions. This is the product of negotiation. When you have hard bargainers on both sides of a negotiation, nobody gets everything they want. And so you're really trying to decide whether this is good enough to accept or whether we should reject it and face that unknown that rejection really represents. And, you know, going forward, if the city rejects this, we may be subject to more hard negotiations. We may, in fact, have to go to trial on this matter, or we could ask for a Superfund designation. But the question before us right now is whether to accept or reject this. And so if you recommend one or the other, you should give us reasons why you're recommending that, not ask us to go and seek something better. Honestly, we sought better. And so you just need to know the restrictions on what's possible as the next step. Thanks so much for everything you guys do. I really appreciate it. And I hope that you'll give us a strongly worded recommendation. Thank you.
Okay, thanks, Jack. Who's the next caller? Do we have another caller on the line?
No, we don't. No one's hand is up.
Okay. I'll wait a few seconds then to close public commentary. Okay, do I have a motion for adjournment? Do I have a second? John Calloware, seconded by Rita. All who agree, raise your hands. All who disagree, raise your hands. All who vote no. Okay, the motion passed unanimously. I declare this meeting adjourned. Thank you, everybody.
Thanks, Steve.
Hi, everybody.